Okay, so good morning, everybody, and thank you for joining us today for the third in a series of webinars that I'm doing for my clients with an introduction to series. And today I've got Andrea and Nicola joining me from Legacy Services, who are going to talk to us a little bit more about the importance of wills and powers of attorney. And so over to you guys.
Thanks very much. Thanks for the invite and thanks for asking us to talk. So I'm Nicola. Andrea's one of my colleagues. We are both estate planning consultants for LB Legacy, and we're here today to talk to you a bit about why it's important to have a will and just as important to have powers of attorney. The shocking statistic that we often talk about is that nearly 2/3 of UK adults don't have a valid will. That actually means that 27 million people in the UK don't have a valid will. If you're in that majority, then don't worry, because obviously we're here to help you. But the reality is that more people don't have a will than do have a will. So we always start with that statistic because quite often people are worried that they haven't got one, but you're sort of in the majority. But that doesn't mean that you don't have to do one. So why do you need one? So first of all, let's talk about what is a will. So a last will and testament is a legal document. It allows you to give instructions and also to give authority to people that you trust about what you would like to happen when you're no longer here. That's in its simplest form. That's what a will does. Why do you need one? You need one just really to make sure that your wishes are carried out. There's lots of myths around wills. We're going to talk around some of those, and lots of people have many assumptions around what would happen if you died without a will. If you don't have a will, then your estate is declared intestate. So a testator is the person who makes a will. Intestate is the phrase that we use when you don't have a will. And what happens then is that the law then decides what happens to your estate. And that's according to a set of rules that were devised in the Inheritance Act. And those haven't changed for a long time. So for some categories of people, that could be an absolute disaster. So having one allows you to take control of what's going to happen to your assets when you're no longer here. Not having one means that you give up control and someone else makes those decisions. So that's one reason why you may need a will. There are many others, and we're going to talk around some of those scenarios. I always say actually that one of the main reasons for making a will is because it's actually the kindest thing you can do. If you pass away and you haven't made a will and your family don't know what you wanted, or they have to fight to get what they think they're entitled to, or they are dealing with the banks and many other organisations without having the right authority in place, it makes it really difficult for them. So making a will is actually the kindest thing you can do for the people that you're going to leave behind. So let's talk about a couple of scenarios, that real life scenarios of why you might need a will. And the first one we always talk about is if you're unmarried. So I talked a little bit about the Inheritance Act, and the Inheritance Act is a set of rules that lays down what happens if you don't have a will. And they do not include unmarried partners. That there is absolutely no provision. So if you are unmarried, you're living with your partner, you have absolutely no rights to any of their estate. In fact, you actually don't even have rights to do a lot of things, such as arrange a funeral, for example. But the most important thing is that your partner has no rights to any of your estate. So if you get married, you do have some rights, actually. So the Inheritance Act allows for the first 270,000 of your estate to go to your married partner. And then if you have children, half of everything else goes to your married or civil partner, I should say. And then the rest goes to your children. But one important thing to understand is that if you make a will before you're married and then you get married, your previous will is revoked automatically. And that's done actually to protect you so that you actually have the law on your side, the Inheritance Act on your side, but many people don't know about it. So I wrote a will a few months ago for a couple who had bought a house 14 years ago, and very sensibly they actually made a will, and then they got married a year after they bought this house. So for 13 years their wills have been revoked, and they didn't have an actual valid will in place. So when I went to see them, they were horrified that actually the will that they thought they had in place was no longer valid and hadn't been valid for 13 years. So that's really important. You need to make a will if you get married, because your previous will is revoked automatically. You should also make a will if you're separated or divorced. There are some provisions in the Wills Act that remove a divorced partner from the provisions of your will. But of course, if they were, if your previous husband, wife, married or civil partner was your executor, for example, you may no longer have an executor of your will. If they were the main beneficiary, of course, you may no longer have someone there. So it's really important when you become divorced to make a new will, even though your ex-partner is actually, to all intents and purposes, cut out of the will that you had. But it's just as important to start thinking about making a will when you actually separate. So for many couples, they might have jointly held assets, and you may not want, through the process of being separated and before a divorce agreement, you may not want them to still benefit. So we always suggest that you make a will as soon as you decide to be separated. You can update it again when you're divorced if you need to make further provisions, but it's really important to at least be thinking about protecting maybe your children instead of your estranged partner. You really, really should make a will if you have children from a previous relationship. This is something that we see many, many, many times. So quite often children from a previous relationship can be accidentally disinherited by the fact that you are going to leave everything either through a will or by accident to your new spouse. And that might mean that if they married again in the future, or even made a new will, they could pass everything to their children and not to yours. So it's really important to protect your own children, to make sure that you have a will in place. We often talk to couples who've just bought a new property as well. And depending on the way that you own your property, that property may not automatically go to your to one of the joint owners. And there are provisions that you can make to make sure that it does. But also you can make sure that your share of the property, for example, does go to your children from a previous relationship. So when you buy a new property, you should always take the chance to look at your will. And when we talk about when do I need a will, this isn't just about making a will, it's actually also about updating your will. So quite often your circumstances change. For example, you've got married, you bought a new property, and for the next point, you know, you've just had a new addition to the family. We recommend that you update your wills every 3 to 5 years. So if you've got a will, well done for having one. But if you have one and it's more than 5 years old, we would absolutely suggest that you review it, because many of these circumstances may have come to fruition in the last 5 years, for example. So if you just bought a new property, if you've had a new addition to the family, we see quite often you know, wills that would say, oh, I give an amount to my grandchild Emma, and then all of a sudden Emma now has a new brother. So, you know, if that will wasn't updated, then Emma, the granddaughter, would get a legacy, and Joe, the new grandson, wouldn't get a legacy. So, you know, if you just had a new addition to the family, maybe as a grandparent, but really importantly, if you are a young parent and you have children, you really, really should make a will to protect your children and name a guardian. So what many people don't realise is that if both parents passed away, and not something we want to think about at all, but the law the law allows you to name a legal guardian, but if you haven't named a legal guardian in your will, social services will decide where your children are placed. And that may not be with the people that you would want them to reside with or have the right authorities to help them through the rest of their life. So when you've had children, we often see people who'll say, I'll make a will now that the children are 18 and I don't have to worry about guardians, which is really frustrating, because actually as soon as you've had children, that's the point to make a will. make sure that you appoint a guardian in your will. It gives them the ability to work through the social services system with the right authority. So many of you might have financial circumstances that have changed. For example, an inheritance. So an inheritance, maybe an extra amount of money, you may not have considered what you might want to do with that. It might give you an inheritance tax issue. So you should always try to look at your will when your financial circumstances have changed. And then another reason to make a will is to protect vulnerable people in your life as well. So for some of us, that vulnerability might be maybe a relation who has maybe an addiction problem, for example, or may have some physical or mental disabilities. And that might mean that giving them an inheritance directly or giving them an inheritance accidentally through not having a will may have a devastating effect either on their life because they don't know how to handle money, or on their benefits because those benefits are means tested. So if you have people in your life that are vulnerable, either from an addiction, maybe that gambling, maybe drugs, those sorts of things, that you need to help them to manage money that they may inherit. You don't want to cut them out, but you do want them to inherit. Then we can make use of trusts to make sure that those vulnerable people are protected. So those are all the reasons. Well, there are probably many more, but those are the main reasons of when you should make a will or when you should update a will. Okay, so I'm just going to quickly go on and talk around some of the myths. I have sort of mentioned some of these. The first myth: everything will go to my partner anyway. We hear this day in, day out. Andrea, I know you hear this all the time as well. And the reality is, I've just sort of alluded to the Inheritance Act. So if you are married or in a civil partnership and you have children, only the first 270,000 of your sole assets will go to your spouse or civil partner. And the rest will be divided between that partner and your children. So that can be, in some circumstances, and we have seen it, a house that is jointly owned, and now you are a owner, not with the partner that you've just lost, but with their children, maybe even from a previous relationship. And that is a common occurrence because there is this allowance of 270,000.
Sometimes that's led to people actually losing their home, because if the adult children, stake claim to that and want it straight away, and they aren't the forgiving, grieving children in this scenario, then sometimes people have been forced to sell the family home, which is terrible, particularly at a time of grief as well.
Exactly.
It's staggering that people don't realise that. Yeah.
Exactly. And that can be the same situation as well, Andrea, where, so I'm talking about married couples here, everybody has this assumption, not everybody, many people have this assumption that, oh, well, we're married, it's fine. I don't need a will because we're married and I'll get everything anyway. When we talk about unmarried partners, and I've already said this earlier, that's even more important. It will not go to your partner. Okay, unless you own the house in a specific way, it will not go to your partner. And therefore, what Andrea just talked about, adult children from previous relationships, can get involved, and also other members of the family. So a really good example, I have a client whose partner, long-term partner, for 28 years, they'd lived together. The house was in his sole name. He died in February. She now no longer can live in that house because he didn't have a will. His estate is going to his brother and sister. They have now sold the house, and at 58 years old, my client is now living back with her parents. So she had no right to his estate. So, the myth around everything will go to my partner is probably one of the biggest ones. Yeah. So one of the other myths are wills are for the rich. We hear this a lot. I don't have anything. Why do I need a will? The reality is, I've talked about some of those things. So if you have a partner, but particularly if you have children, you may think you've not got a lot. You may not even have a house, But the main reason for making a will, if you are a young parent, is to protect your children by naming a legal guardian in your will. So wills are not just for the rich, absolutely not. We have many, many, many customers who don't have large estates. They would never have a problem with inheritance tax, and they absolutely need a will. And that's sometimes because what you want to do is you just want to make it easy. We have somebody who came in last week. He's a single gentleman, older. All he has is his sisters. He has £50,000 in the bank and no house. Why does he need a will? Well, he needs a will so that his sisters have the right authority to deal with the banks when he's no longer here and make sure that what he wanted from his funeral wishes and from some small gifts that he wanted to give away that were family heirlooms, that it's just made easy and it's made simple. So wills are for the rich is absolutely a myth. Yeah, they are definitely not. They are for everyone. Just this morning, actually, I saw something on Facebook that said, my wife died and the will and her estate still had to go through probate, even though we had wills. And then I had someone else who mentioned, replied to that comment saying, well, I was told that every will has to go through probate. It's absolutely not true. So first of all, probate is the Latin word for proving. So it's to prove. Probate is to prove a will. What that does is it makes an official representation and gives you the official powers through the court of probate to allow you then to, as executor of the will, distribute the assets. So when do you need to go through probate? An estate needs to go through probate if there are sole assets in of £5,000 or more. For some people, the gentleman I talked about earlier who has £50,000, his estate should go through probate. The reality is, if the bank have limits that allow all of that money to be released without a grant of probate, he probably doesn't need probate. But the reality is, making a will does not stop you going through probate. And not all wills and not all estates need to go through probate. So that's another myth. People think, oh, if I make a will, I don't have to go through probate. That's absolutely not the case. It is still needed in many circumstances. And then probably the biggest myth is I can DIY it.
No.
Andrea and I see DIY wills on a regular basis. In fact, I videoed myself actually going to the post office and buying one of these last will and testaments for £6.99 and opening it and having a look at the provisions. So I will absolutely say, if you have the most basic estate, and maybe the gentleman that I talked about with just the £50,000 and no house, leaving everything to his two sisters, probably in very limited circumstances like that, a DIY will may be okay. But actually DIY wills don't include, in many cases, substitutes. So they appoint one person as an executor, the person who sorts out your will, and quite often appoint one or a couple of people as beneficiaries, the people who benefit from your estate, and very little else. So I have an example of a real DIY will disaster, where I have a client who came to me, her father and her stepmother had made DIY wills that appointed each other as sole executor, they'd appointed each other as sole beneficiary, and there was no provisions for any of the children. The father is now in a care home and has no capacity, and the stepmother has now died. So the stepmother's estate can't be administered by the sole executor. And so we're going to have to, get some help for them to do that. But all of that money is now going to go to the gentleman in a care home and just be swallowed up in care fees, because there was no other provision. And the lady didn't understand the consequences of what it was that she was doing. So her children and his children are going to miss out on their inheritances. And that's just one example of a DIY disaster.
It really is staggering that for you know, that the wealth that people have created by working hard, a lifetime's worth of work put into a house, into savings and shares, premium bonds or whatever, to not spend an hour of your time and the you know, the relatively small amount as a proportion of what you're talking about to actually sort this out, it is mind-blowing. And until I entered the industry, I had absolutely no idea that people would even consider doing this, but they do. And I don't think between us we've ever seen a DIY will even that would actually even be legal. So many are just incorrectly drafted or not witnessed properly, and they're not even the DIY version isn't always worth the paper it's written on, is it?
Exactly. I mean, not even worth £6.99, as you said. So, I mean, Andrea makes a good point there. You know, that, you know, in order for a will to be legally valid, legally binding, it has to be executed properly, and that means signing it in front of two witnesses, and that means in the presence of two witnesses. And we see so many of these DIY wills that weren't signed properly. They don't have the right number of witnesses. They're not signed in the right place. You know, and that just makes it invalid. So it wasn't even worth doing anyway. No. So, you know, we talk about DIY wills all the time, and you know, the challenges that they can bring. Our advice is, you know, as Andrea said, spend an hour, maybe a couple of hours at the most, you know, spend a couple of £100 and get at least a simple will, you know, and you can make it as complex as you want and add more things into it. But a basic simple will, you know, doesn't take that long to do, and actually is much better done by someone with experience. So a really good example actually is in our wills, we always put in something called the digital assets clause. So more and more and more of us now own digital assets, you know, whether that be photos of your family, whether that be Bitcoin, whether that be email addresses, etc., etc. DIY wills, and many of the cheap free wills actually are the same, don't include clauses like that. So actually the practical challenges that you come across when you lose someone and now you can't access those family photos, for example, because you don't have the right powers, is just something that can be a complete disaster. And that's going back to when I talked to right at the very beginning about making a will is the most, you know, one of the kindest things you can do. It just makes it so much easier. And so having a professionally written will actually does include all of those clauses. So not only do we say make a will, we also say take advice and make a professional will. So powers of attorney, we talk about wills a lot, and I talked around the fact that 2/3 of us don't have a valid will. Personally, I believe that a power of attorney is more important than a will. So I've just talked a lot about wills, and I do talk a lot about wills and the importance of having one. But having a power of attorney is more important than having a will. And why is that? So with a will, if you don't have one and you die, there are rules in place that allow your estate to be distributed. You may not agree with those rules, and it may be more difficult for your family, but there are rules in place. The law takes care of your assets and your estate. There is no such law that allows your family to act for you if you lose capacity. So the law is not your backup if you have a problem when you're alive and you need people to do things for you. And in order to do that, you need a power of attorney. So I'm just going to talk through a little bit about what a power of attorney is and why you need one. And then we're going to talk a few myths around powers of attorney. So powers of attorney bring additional peace of mind. In my mind, they're probably more important. People do get them mixed up. So they think that when they've made a will, oh, I have attorneys. That's not the case. When you make a will, you are appointing executors. When you're making a power of attorney, you are appointing attorneys, and attorneys can act when you're alive, and executors act when you're expired. So that's the easy way to remember it. Attorneys for when you're alive, executors for when you've expired. And when you make a power of attorney, it stops at the moment you die, and the executors in your will take over. So Lots of words here, but in essence, there are two types of powers of attorney, or two types of lasting powers of attorney. There is a property and finance power of attorney, and that allows attorneys to make decisions on your behalf around personal finances and properties. It's much more than just finance and just property. So yes, it does allow you to sell a property. Yes, it does allow you to access someone's bank account, but it does much more than that. It allows you to deal with all of those institutions or organizations, I should probably say, like the Department of Work and Pensions, like actually talking on your behalf to someone like your financial advisor at Leicester Brunt. It allows you to pay utility bills. It allows you to do things like insurance, organising and claiming on insurance, etc. And it can be used as soon as it's registered. So you can make these documents in advance. So let's say, for example, you've decided you want to go off for 6 months around the world. You can set a power of attorney in place in advance to allow someone to do all of these things, maybe look after your rental properties or deal with your finances or whatever else it might be whilst you're away. So you're taking a break, for example. So you can register them and use them straight away. Health and welfare can only be used whilst you have no capacity. So the other power of attorney is for health and welfare, and that allows someone to make decisions on the donor. You're the person donating the powers to your attorneys and giving them your authority. So it allows someone to make decisions on your behalf about personal welfare, about care, and about treatment. So it can be anything. You know, it sounds simple day-to-day decisions about care homes. That's not a simple decision for anyone. But, you know, if you've lost capacity, which care home do you need to live in? Are you going to have care at home, actually? Or would you be better in residential care? Is that going to be somewhere that's near? Is it going to be a private home? Is it going to be a council-run home, etc., etc.? It also allows you to have the ability to make decisions whilst people are in a care home about maybe their daily diet or the way that they dress, or, you know, how many times they have their hair done, for example. I mean, my mum is in a care home, and, you know, we have a power of attorney, and, you know, we've given them authority to spend every other week for my mum to have her hair done. Yeah. And that's because we have powers of attorney. The ultimate power that you're actually, or authority really, I suppose, is giving your attorneys the ability to consent or refuse to life-sustaining treatment. And so practical examples of that obviously could be something like the decisions around switching off life support, but can be, you know, life-sustaining treatment can be many other things. It can be antibiotics if you have sepsis, for example, or it can be chemotherapy if you have cancer. Those are really wide-ranging powers. And without a power of attorney, the reality is that your next of kin has no legal authority to make those decisions for you. They will be informed, and to a certain extent, they will be consulted by the doctors who are looking after you. So let's say you've had an accident or a stroke, or you're in the later stages of dementia, for example. The doctors will consult and inform your next of kin, but you cannot talk for your next of kin. Sorry, your next of kin can't talk for you. So we talk about a power of attorney being your voice. This is you giving someone the ability to talk on your behalf and make decisions on your behalf when you're no longer able to. So those are the two types of powers of attorney. There are a couple of other powers of attorney that some clients may already have in place. So one is called a general power of attorney, sometimes called an ordinary power of attorney. You can get these from the post office. These actually cost £10.99 in the post office, by the way. But they are not accepted by all organisations. Yeah, so Department of Work and Pensions, for example, don't accept an ordinary power of attorney. They only cover health matters. Sorry, they don't cover health matters. They only cover finance matters. They can only be used while someone has capacity. So for some people, that might be useless, really, because it's really want it for when they've no longer got capacity to make their own decisions. It is valid as soon as it's signed, so it doesn't need to be registered. The lasting powers of attorney I talked about before need to be registered with the Office of the Public Guardian. That's the court of protection. They are the people who are responsible for safeguarding you as the donor and making sure that your attorneys don't do something that you wouldn't have wanted. Although don't appoint someone as attorney that you don't trust. So general powers of attorney are valid as soon as they're signed. So they're really, really useful as an interim whilst you're waiting for your powers of attorney to be registered at the Office of the Public Guardian. And at this moment in time, registration used to take somewhere around 8 to 10 weeks. It is now taking 20 plus weeks. That's 5 months. So if you start a power of attorney today, by the time they've got drafted and signed and then registered, that's 6 months down the line. Okay, so we sometimes issue these as an interim solution, but they must be viewed as only an interim solution. So if you go off into the post office and get your 1099 ordinary power of attorney, don't think that it covers health and don't think that it covers you for when you've lost capacity. They are very useful as an interim solution, but that's it. So that's general powers of attorney. Now, some clients, some older clients may have something called an enduring power of attorney. And these used to be issued up to 2007 when lasting powers of attorney became the things that we now issue. So enduring powers of attorney are older. People have them, you put them in your drawer. The way that this works is you put them in your drawer, and when you need it, because you've lost capacity, you register it so that your attorneys can use it. Okay, so it only covers finance. There's no health or welfare or treatment powers in this at all. It can only be used when the donor has lost capacity. And as I just said, it needs registering. But I also just told you that it's taking 5 months to register. So if capacity has now become an issue, yeah, you've got dementia and you are deteriorating, you have maybe motor neuron disease, or you might have multiple sclerosis, or you might have all of those sort of deterioration types of things. Or the more worrying one is you've had an accident or a stroke. Then you now have to wait 5 months. You haven't got capacity and your family have to wait 5 months, or your attorneys have to wait 5 months before they can use it, because it takes 5 months to register. So the really critical thing with powers of attorney is do them, and do them well in advance, and get them registered. You can't do that with an enduring power of attorney. So if you do have those things, you may think, oh, I've got a power of attorney, it's useful. It's actually useless, because once it's needed, it's too late. And the same with health. I hear lots of people say, oh, I'll just make the finance power of attorney. I'll make the health one when I need it. When you need it, it's too late, because you've got to wait 5 months at least for it to be registered. And so our message to everyone is, sorry, Andrea, sorry.
And how many phone calls a week do we get for people ringing up and saying, my mom or my dad has got dementia, I really need to be able to help them. Can I be their attorney? No, you can't. That the mum or the dad have to do this in advance and make you their attorney. You can't choose to be an attorney for somebody else. And once somebody has got dementia, then it's too late for them to do it. And we get many calls like that every week. People think, well, I'll do it when I'm a bit older. And then, that older comes and health issues may have started, and then it's suddenly too late. And just best to just get it done. Yeah.
It is.
I find it a little bit.
Oh, sorry, Alex, go on.
I was going to say, I find it, it's a little bit odd that with enduring powers of attorney, that obviously when you've got someone that's got capacity that's becoming an issue, you're relying on them to actually remember where on earth they've placed these documents so that they can be registered. And that is what I've experienced previously is one of the biggest hurdles, because it's happening after the fact almost.
Yeah, it is. And the critical thing, and Andrea sort of just talked about then, when we get calls to say, my my parents are, getting older, they're losing their memory or whatever else it might be. Can we make powers of attorney? You can only make a power of attorney when you have capacity. So we talk about having powers of attorney in the drawer ready to be used, and enduring powers of attorney are sort of like that, but because you have to wait for them to be registered, they become a problem. So what we say quite often is make your powers of attorney when you're young, you're healthy, there is no concern about your capacity at all. Now, if you equate that to something like insurance, you insure your house. So you spend hundreds of pounds every year to insure your house. And you do that because if you ever had a fire or a flood or a burglary, you're protected. Now, you don't do it because you expect to have a fire or a flood or a burglary. You do it in case. And so and my goodness, are you happy that you had that insurance in place? So we look at powers of attorney quite often like insurance. You don't make them because you think you're going to have an accident or you're going to get dementia or you're going to have a stroke or any of those things. You make them just in case. And actually you make them, there's a one-off cost. You may be spending a few £100s to get it done and then to register it. But then it sits safe either in a drawer or hopefully somewhere stored. We offer safe storage for wills and for powers of attorney. And when you need it, it's there. And you know what? We hope you never need it. But the reality is it's there. It's like having an insurance policy and you don't pay again. So the other option is if you have, say, the accident. So we talk a lot about Kate Garraway from Good Morning Britain. Her husband, during COVID, went into hospital. They had no powers of attorney. She didn't have the ability to claim on the car insurance when his car was stolen. She didn't have the ability to claim on the mobile phone insurance when one of her children lost their phone. She had to buy it again. But most importantly, the bank froze their joint account, and they do it. They do it to protect and safeguard the person that's ill, so that Kate couldn't just go and draw all of Derek's money out and go and spend it. So the joint account was frozen. Now, her only option now, because he didn't have capacity, is to go and get something called deputyship. So deputyship is issued to screened, they screen you very hard, to their selected, their approved deputies through the Court of Protection. And that can take up to a year, and it can cost £3,000 to £4,000 in legal fees. But not only that, you are supervised. It is supervised deputyship. So, instead of being an attorney for someone, because this document was in place already, you are now a supervised deputy, and the screening and the supervision that you're under is very strict. And not only that, you have to renew it every year. So every year you've got to go back to the court with a report and then get approval to carry on. That's the alternative of not having a power of attorney in place. So our message is just do it. Do it when you're young, do it when you're healthy, do it when you're fit, and it's just there to be used. So I'm going to quickly, I've talked about quite a few of these things, but I'm just going to quickly talk about the myths. So this is the biggest myth. My family can sort everything out. I talked a little bit there about Kate and the challenges. She's married to Derek. She didn't have the legal powers to sort everything out. Unlike wills, there is no law to say that your family have the right to access your bank account, to make decisions for you about life-sustaining treatment or surgery or care. They don't have those legal powers. My next of kin can act for me. Very similar. When you go in hospital, they ask you who's your next of kin. And many people think, oh, well, that's because they're going to ask me, if they have to make serious decisions, they're going to ask me, they're going to involve me. Actually, they ask you that. So who's got the right to ring up and ask how you are and get information about you? Who's got the right to be informed? And that's it. There is nothing else. So doctors, for example, can say, well, I'm going to sign a do not resuscitate order on this person, and all they need to do is inform the next of kin. They don't need to consult the next of kin, and that person may have had strong views about something like a do not resuscitate order. So your next of kin can act for me. Next of kin is not a legally binding status. It has no powers. Powers of attorney are only for the old. I've just talked a lot about that. Yeah, we have lots of people who say they're only for old people with dementia. It's just the biggest myth about powers of attorney. There are 400 people on life support in this country right at this very moment, and their families don't have powers of attorney. Many of them are young, including a 19-year-old who's had a motorcycle accident, and their families can't make these decisions for them because they don't have powers of attorney. So actually, we believe a health power of attorney, your kids are going off to university, what happens if anything happens to them? Yeah, make a power of attorney. I know they're only 18, but a health power of attorney can be really useful. Your kids are going off on a gap year, yeah? Whilst they're away, yeah, all the things that you can do with them, let them make a power of attorney, so they're not just for the old. And then we talked a bit about this when we talked about wills, but we also say the same thing. You can DIY your lasting power of attorney. You will see all over Facebook and many of the other social medias, don't pay someone to do it, just go and do it. You pay your £82 registration fee at the Office of the Public Guardian, you do it online, etc. Absolutely, you can do that. However, the number of powers of attorney that we see that have been done wrongly, 27,000 powers of attorney that are done by the public every year are rejected because they're wrong. So that just adds more delays. There's a very strict signing order in terms of who signs when and how. But we also, when we do powers of attorney, we talk about what you really want, because your power of attorney has the ability to include instructions and preferences. So we talk about what you might want. We talk about digital assets. We talk about medical records. We talk about, would your attorneys have your will? We talk about, do you have any discretionary managed funds that you might want someone to continue to do that for you? And we also encourage you to write a statement of wishes about what you might want towards end of life, because giving someone that power, the ultimate power to talk about life-sustaining treatment, without giving them guidance, is actually giving them potentially a problem and a burden. So we talk about this, and we talk you through, and we put all of that information together to help you to make a better power of attorney and do it right. Andrea had some clients last year, older couple who were brother and sister, both in their 80s. All they had done was to appoint each other and no replacements. They're now both in their 80s. They're now both failing. Luckily, they still do have capacity to make new ones with a replacement, but they'd done them by themselves and never even thought about replacements. So using professional advice, allows us to make your power of attorney much more tailored, but also to make sure that you don't make some of the common mistakes, such as how people act, when they act, whether they should act together, etc. So you can DIY it. That's not a myth, but you shouldn't DIY it is probably the way that we would put that. So that's everything that I wanted to talk about about powers of attorney. Unless anybody has any questions or any comments.
Yeah, I guess the only one for me is that I guess when you're looking for somebody to write a will and also arrange powers of attorney for you, it's my understanding that people can do that are even not qualified to do that,
Yep.
which rings alarm bells. So what should you be looking for when selecting somebody to do wills and powers of attorney?
Yeah, that's a really good question, Alex. Thank you, because many people think you need a solicitor. The reality is you don't need a solicitor, and some solicitors who dabble in wills and don't do wills as their, solicitors are generalists in many cases. Some solicitors do specialize in wills and probate, but many solicitors are generalists. And so when they dabble in wills, they're not doing it day to day. So you have the alternative is go off and get a free will, do it online. We would say don't do that, because you don't know what you don't know. There is an alternative, which is will writers. LB Legacy Estate Services is a company of will writers. If you are choosing a will writer, I would suggest that you choose someone who belongs to either the Society of Will Writers or the Institute of Professional Will Writers. We belong to the Society of Will Writers. And what that means is that we have to adhere to their code of compliance. We have to do continual professional development. We also have to carry insurance, which is really important if anything goes wrong. Yeah, unregulated companies do not need to carry insurance. The Society and the Institute, who are the two main bodies, are not regulators. So we're not regulated. We self-regulate through those societies, but we have to meet stringent conditions. So I would say, either look for a specialist solicitor if you're going to use a solicitor. Don't use a generalist, or use a specialist will writer. We do this day in, day out. Yeah, so we're not generalists. We only do wills, trusts, and powers of attorney. Yeah, and we also offer an executor assistance service at LB Legacy, of course. But this is our daily. We live and breathe wills and powers of attorney, and that's what we do all day long. So make sure that if you choose a will writer, they belong to either the Society of Will Writers or the Institute of Professional Will Writers, because that gives you the guarantee that they have the right training, the right certification. We have to undertake training and pass an exam to do what we're doing. They continue to increase their training, and they have insurance, which is the most important thing.
Often as well, Alex, many times when people are reviewing the will, whether they've had a change of circumstances or a change of heart about anything, and they come to us for a will, we always ask them about the will that they've already got, if they have one. And often they have been drawn up by solicitors. And when they see our will, when they go through the process with us, all the questions that we ask and all the paperwork that we send, and then we send the draft wills for their approval, our wills, well, for one, are very simply written, whilst they're obviously a very important legal document. They're written in a way that is more understandable. I sometimes feel that people sign things put in front of them by solicitors with all that legal jargon, not always perhaps fully understanding what it is. And I think anyone could read our wills and know what it is that they're doing in their wills. But also, we're often told by people when they've done a will with us versus having done it with a solicitor in the past is, well, we weren't even asked all those things. We hadn't even thought about that. They've ended up with something very basic, and we literally cover every eventuality, whether it's somebody wanting to leave something with their pets, who they want to look after their pets, or certainly naming lots of substitutes. If these people are around, who then? And if they're not around, who then? And really future-proofing it, but taking absolutely everything into consideration. And I can hand on heart say you don't always get that with a solicitor, because people tell us this all the time.
So I think you mentioned earlier that people should be reviewing their will every 5 years. Would you say that the cost to do that, to review a will, is proportionate to the sort of ramifications of not doing so? So I think a lot of people tend to look at these things that are cost orientated, and that might be a reason that they're kind of putting it off.
Mm-hmm. To update a will, there are two options. One is to make a codicil to a will, and that's a formal, legally binding change to a will, which is just an addendum, really. If you think about it, it's a separate piece of paper. And that might say, I gave a gift to my granddaughter, Emma, and now I want to make that gift to Emma and to Joe. Okay, and that's just a separate will. Or you can make a new will. For some people, it's just easier to make a new will. So if we think about, the cost of a couple of £100, to maybe change your will or even to make a new will, depending on the complexity, versus the fallout, the challenge that you could have with losing half a house, not having the inheritance that you might have expected, tax implications. We see quite often people have maybe a large house and, they haven't thought about, we've got a new house, we've now come into a new relationship, and they've not really thought about, how they can protect that. And for the sake of maybe losing half of their house, their share of the house, to someone else's children, a few £100 is nothing, when you have your main assets. So I was looking at that, and I think, it's priority versus price, really, isn't it? And if your priority is protection, then really, a affordable, well-written will is something that should be your absolute priority to make those things happen. Does that make sense, Alex?
Yeah, absolutely fantastic. Brilliant. Thank you.
Yeah. And there's the same reasons for renewing and updating your will, or certainly, looking over it every 3 to 5 years. It's exactly the reason why you need a will in the first place. They're the same set of circumstances, that if anything has changed and what your will says is no longer what you would want, then that's the document that needs updating, doesn't it? Yeah, it does. It might be that there's not been any changes, and a well-drafted will last you longer than a poorly drafted will. So whereas in Nicola's example of saying I leave money to my granddaughter Emma, in that example, we shy away from naming people by names, and we would use what we call a class of beneficiaries, where we rather than saying Emma, we would say grandchildren, and that would then cover any future grandchildren that come along. So a well-drafted will last longer than a poorly drafted will, where you have, or one that you've done yourself and you've named somebody by name. It's then excluding other people. But a properly drafted will, as long as you haven't had any life-changing circumstances, will last you a long time. So that's, a really good reason to get it done properly in the first place, that we future-proof wills as much as possible.
Yeah, I find it just bizarre that someone would go, and buy, a kind of, a DIY will for £6.99. I think you mentioned earlier, Nicola. Given the gravity and the importance of it, that you're willing to commit £6.99 to that cause, just seems extremely disproportionate, as you mentioned, to just the fallout and ramifications of what you're doing. And really, in a roundabout way, when it comes to all these problems coming out, when someone's passed away, the family are going to think, well, what on earth were they doing?
And and if you do have a will, the family will know. We encourage people to write a letter with their wills to explain, if they've made sort of decisions that, may need explaining, to actually explain those decisions. And that's why I go always back to, it's the kindest thing you can do, because not only are you making sure that what you wanted to happen happens, but you're also giving an explanation as well, if that's what you want to do. But you're also saving all of this stress and hassle. I mean, talking about updating wills, and I mentioned briefly separation and divorce. And actually, we had a client last year whose mum and dad split up 30 years ago, and he hasn't seen his father for all of that time. So for 30 years, he's not seen his father, but they never divorced. And his mum's passed away. He's been very close to his mum, very much in contact with his mum, and his mum didn't update her will, That is the reality. She just had a will that left everything to her husband, and because they were still married, they'd only separated, he had everything. So for the sake of even her £6.99 will, which we wouldn't have recommended, but for a couple of £100, his estranged father has now got her full estate of over £300,000, and it's not gone to his son. That's the financial impact of her not updating her will. That is the reality.
Yeah, that was heartbreaking. And the other thing that comes to mind as well is a lot of people put off the will. It's not necessarily a cost factor. They say, we're just, life's so busy. We hear this all the time. We've had the builders in. We're going on holiday. You hear all these reasons. I just need to do this, and then we will get round to it. And I think, how long do a couple spend in going around all the different sofa places, choosing a sofa? They'll, even in one showroom, they might sit on 20 different sofas. Is this right? That's a sofa, it's going to last you 10, 15 years, whatever. And they'll spend the time doing that. That might take a whole afternoon. Doing your will, an hour, and 1 hour to sort your life out and just get everything in place for everyone and save the absolute fallout. And there's nothing like a newly grieving family going through the upheaval of somebody not having a will or a badly drafted will, that makes them realise. And if you were privy to these people that we speak to day in, day out, it's like you want to capture what they've said and pour that heartache and upset and grief and devastation that they're going through and shout it out to the world. You know, we know what these people are going through. We speak to them all the time, and just do it. You know, an afternoon in a sofa shop, or you know, an hour sorting your will out. It's just no beggars belief. Yeah.
I guess you've got the other side of it. Like, once people have done the will, and then they are, you know, it's that peace of mind. So they can then focus on something else, and also just, you know, I think perhaps not having a will and having this kind of animosity can be quite stressful in a way, because you've got so many loose ends to tie up. So I'm sure, you know, experience this quite often where someone's done the will and it's just that sigh of relief. And now, you know, they know that everything they wanted is going to be.
Andrea and I always say, if we had £1 for every time somebody said, oh, I've got peace of mind now, oh, I'm so glad I've done it, or I feel so relieved, we would be multimillionaires.
Brilliant. Well, thank you. That's answered my question. Well, I guess this just leaves me then to draw our meeting to a close. So thank you very much, Nicola and Andrea, for joining me today to explain a little bit. And actually, I learned something today as well with wills and powers of attorney. Hopefully you guys found it useful as well. And if you've got any questions or any queries, please do reach out to myself or the team there at Legacy Services, who are more than happy to help. But otherwise, have a fantastic day and see you soon.